First thing that I usually tell people to do, even before you contact an attorney, is grab one of those little 79-cent spiral notebooks. And on the front of it, you'll write notes for my attorney. It keeps it protected from anything discoverable.
Hello, everyone. This is Gretchen Baskerville, and I'm the author of The Life-Saving Divorce, Hope for People Leaving Destructive Relationships. And I'm just thrilled to have my friend Laura here. She is a paralegal in Texas, and she's going to just talk about some general tips. This is not legal advice, just general tips of what you should do when you face the idea of starting with a divorce. So welcome, Laura.
Thank you.
Take it away. I think what you already brought up before we started the recording is the number one thing people ask is, where do I start?
Okay. Again, like you said, I'm a paralegal, so I'm not giving legal advice. And what I'm going to say is primarily, it's what's true in Texas, but a lot of my advice will carry through from state to state. First thing that I usually tell people to do, even before you contact an attorney or when you've called my office, is grab one of those little 79-cent spiral notebooks. And on the front of it, you'll write notes for my attorney. And the reason for that is it keeps it protected from anything discoverable. And you can immediately start making any kind of notes as far as who has possession of the children at what times, any significant expenses that are taking place, any bank transfers that you've noticed, just anything that you think might come up during the pendency of your divorce case. Some things are going to reflect on you well, some things are not going to reflect on you well, but we need to know everything. It's not shared outside of what your attorney is. During the divorce process, attorneys can send requests, discovery requests, we call them, to the opposing party, and then the opposing party has 30 days typically to respond. They can ask for all of your bank statements, all of your vehicle titles, all of your credit card statements, any calendars that you have. They can ask for any journals that you keep.
They can. Oh, wow. Okay.
So just know that all of those things are discoverable. And if you do not respond to discovery, they can file a motion to compel. And if the court says that this is something that's legitimately needed for the case to figure out what's the fair and just solution, then you can be forced to produce those things. And if it comes to a motion to compel, you can also be held responsible for the other person's legal fees.
Oh, wow. Okay. That's good to know. So before you take even one step, put aside your personal journals. If you're a journaler, get this brand new notebook, right on the front cover, notes for my attorney, yes. And then continue journaling as you always have and taking notes and writing all your calendar things in that particular notebook.
Exactly.
And that cannot be
no, that'll be protected by attorney-client privilege.
Oh, wow. That's great. Okay. You just gave us $100 worth of value right there. Thank you. Okay. Then where do you go?
I usually tell people, if it's okay to just meet with one attorney if you instantly click with that person, but it's always a good idea to meet with several attorneys. And don't always expect a free consultation. Just like anything else, legal fees you're going to get what you pay for. And if somebody says that they're going to handle your divorce for $1,000, they're probably not going to handle it well, because the filing fee alone in Texas is $300. So if you think about how hard somebody might want to work for you for $600 in income, versus an attorney that says a $2,500 retainer or $5,000 retainer or even $10,000 retainer, depending on your circumstances. So that's just one thing to consider. And a lot of times people also get intimidated by the cost of having a partner level attorney versus an associate level attorney. The $400 attorney versus the $200 attorney. Typically, an associate will probably take almost twice as long to do the same kind of work. So in the end, the amount's going to balance out. So don't necessarily look at the dollars and cents and titles. Look at who you feel most comfortable with.
Okay, excellent.
That person is going to dig very deep into your life, and it's important that you feel like you can be open with them and that you are getting the sense that it's a non-judgmental environment. So even if you have some dirty laundry of your own, and most people do, you have to feel comfortable with disclosing all of that, because the worst thing for us is to get blindsided in a hearing with, oh, you forgot to tell me about those texts that you were sending or something along those lines.
Okay, so you're going to have to go open kimono. You're going to have to be honest with them. Tell the
Yes,
good, the bad, and the ugly. Okay,
absolutely.
that's good to know. So a lot of people wonder, how can I keep my legal costs down? Are there things I can do outside of what my attorney is doing, or to prepare for meeting with my attorney to get those costs down, just get certain things done?
One of the simplest things people can do is have all of their statements and all of their important documents scanned so we can get electronic copies, so we don't have to take the time to scan everything. And once something is scanned with today's technology, we can actually, just hit Control F and find the words that we want to find versus perusing 236 pages of documents to get to the nugget that we need.
Okay, so and when you're talking about statements, you're talking bank statements, retirement statements,
yes,
any investment states, Vanguard, Fidelity,
yes,
anything you're getting from your bank. What
and
else?
then as far as your children's documents, of course, all of their health insurance, if you can get their medical records, if there's something that's relevant, especially if you're dealing with a child with some kind of disability that may entitle you to longer term child support or adult child support, as we say. Make sure you have all of their medical records ready, so we don't have to issue subpoenas and add expense to that. And also, again, a digital copy is definitely preferred, at least in our office. Some attorneys' offices don't have those capabilities, but most of the larger firms will have that.
Quick question on that. So you just call the pediatrician and say, I need my kids, a copy of my kids' electronic
Yes.
medical records. That's it?
You're a parent. You're entitled to that information.
Okay, good to know.
If your child is in daycare, get the schedule of who's been dropping the child off, who's been picking the child up, who's been coming and showing up for lunches with the children. Same thing with school-age children. Has mom or dad been checking into school to have lunch with the child, checking the child out for early release to take to doctor's appointments. In Texas, we have something that's called the Holley Factors that help determine the best interests of the child. And it'll ask things like, which parent was the primary caregiver before this case was initiated? And having third party backup to that, in the form of school records, teacher conference notes, and things like that are also very helpful.
Okay, so primary caregiver, it sounds like you're telling me you need some kind of third party verification. So if you can get something from the school, or maybe let's say there's a secretary at this who handles things for the soccer team, that they're the one who says, yeah, it's always mom or it's always dad who's at the games, who's at the practices. So you need third party verification.
It's very helpful. In highly contested custody cases, it's a very helpful thing to have.
Okay. And as long as we're talking about that, does it help to have, just letters from friends or letters from the pastor, or just even a coworker who says, boy, your ex, soon to be ex, is driving you crazy. Your soon-to-be ex is always trying to get you to leave work early because they're dropping the ball on picking up the kids. I mean, do those kinds of things help?
Absolutely. That kind of documentation is fantastic. And we've even had cases where, one partner is being, I won't say abused in such a way, but it's difficult to actually pinpoint what I would call this, but somebody who's receiving a great deal of phone calls at work, personal phone calls at work by a spouse that's being harassing and annoying, to the point that they've been written up. I have seen cases like that. And
Oh, wow. So if your soon-to-be ex is calling you constantly, is texting you all through the day,
yeah,
and
and
it's
your boss is
interrupting your
taking
work.
notice of that,
Mhm.
that's definitely something that the courts are going to want to be aware of. And there are procedures in place for handling such behaviors.
Okay. Okay. Now I've heard that some people have such aggressive and harassing spouses that they actually try to get them fired. So I imagine the same thing applies there. If that's what your ex tries to do,
Yes,
have your supervisor document it, or your coworkers document it. Okay.
yes.
What other documents do you need to get, or other things you need to look into that people are surprised to find out about?
Um, I think as far as documents and the notes that we've talked about, the journal things that we've talked about, I think we've kind of covered that pretty well. You're going to need to provide a full witness list under required disclosures, and they're called different things in different states. Most states are making those mandatory, where you do some initial disclosures of who you may have testifying.
Mm.
And so you want to provide a thorough list, because usually when you give a person, when we provide that list to the opposing counsel, we can't come back 30 days before a hearing or trial and say, oh, by the way, we're going to have this person as a witness.
Oh, wow. So you need to
Under the
start thinking
rules,
about this in
yeah,
advance.
under the rules
Anyone
of
you
procedure, you'll want to know those things.
and the kind of people you want to put on this would be people you've told in the past, or who should go on these lists?
Pastors, support group leaders, employers, if, like the case we were talking about, if somebody is being harassed at work, obviously all your close family members, not only from a standpoint of being able to testify as to somebody's, bad actions, but also they can testify as to the support network that's in place for the client and their family once this divorce has taken place.
Mm.
Because family support networks and friend support networks are very important. Um, any of
And
your therapists, doctors,
oh,
um, if a doctor is under the situation where you've had to be prescribed anti-anxiety medication or antidepressants, these are things that you need to make the attorney and the court aware of.
so does that go against you if you've been prescribed medications?
Absolutely not. Absolutely not. I have seen opposing parties try to make it an issue. I don't think the court thinks too highly of people who try to put down other people who have mental health issues, as
That
long
is
as
going
the
to
person is being safe and keeping the children safe.
Okay, so that's the number one thing. Keeping
Exactly.
as long as they're taking care of themselves
Yes.
and taking care of the kids,
Yes.
won't make you look bad at all. Excellent. Because I know people are really worried about that kind of thing. They worry that their ex is going to try to make them out to be crazy. So having the doctors, whether it's a psychiatrist or a psychologist, actually makes you look good, because you are taking steps to
You're
take care of your
handling
mental
your,
health.
yeah, handling your stuff. Exactly.
Ah, that's
So
good to know.
the courts want to, the end goal of the courts is to make sure that each child has two healthy and happy parents and households.
Okay.
That's the primary goal for the best interest of the kids.
Now, a lot of people say, I don't have any bruises. I don't have any broken bones, and neither do the kids. But wow, the emotional manipulation and abuse and pressure and the coercion is unbelievable. How in the world do people document that?
We see a lot of, like, especially it seems to be a surgence of parental alienation cases that are
Hmm.
taking place, a lot of financial abuse that happens in homes, and a lot of emotional abuse that takes place in homes. And again, make sure you're journaling these things, seeking out the right mental health care for yourself, or seeking out the right counselors is needed. In some cases, it might be a financial counselor that's needed. And making sure that we're all staying in touch with each other to know what's going on. I'm free to speak with counselors, financial counselors, mental health counselors, as long as the client gives the HIPAA consent, so that we can make sure that we're addressing everything the right way.
Okay, so by going to a counselor about an emotional abuse issue, you're documenting it. Is that kind of the point?
Yes.
Okay.
And their notes, again, like attorney-client privilege, you have the medical provider-client privilege. Their notes will not necessarily be accessible to the court, but any medications that are being used, a general experience interaction testimony is okay. So that a therapist can say so-and-so presents as well-adjusted and managing this. And they can specifically say, okay, this person has been diagnosed with a bipolar disorder or depression issue, but this person is receiving treatment, 4 times per month, and it is going well, and the person is sticking with the program that's been advised.
Excellent, because I know a lot of people have struggled with a depression, or maybe, bipolar, what we used to call manic depression.
Mm-hmm.
And they're nervous because they're convinced that their ex will use that against them. So what you're basically saying is, as long as you're getting regular treatment, as long as you can
Yes.
prove that, as long as your
Yes.
doctor will say that,
Yes.
you shouldn't be as worried as you are.
Yeah.
So,
and there's a lot
okay.
of people who never have any of these issues until it comes to the divorce. And the divorce itself is the beginning of these issues popping up.
Yeah, absolutely. Yeah. Of course you're depressed. I mean,
Yes.
you've got a lot going on. There's a lot going on. Now, I know a lot of people will say, my ex cleans up so beautifully, puts on a suit, hair done right, looks great in court, presents well. They're going to just fool the judge. They're going to fool everyone. What do you say then? You're laughing.
Well, I usually tell them they clean up pretty well themselves, first of all. And we do coach our clients on, what to wear, presentation in court. We do practice question and answers to help them prepare, because nobody goes through litigation enough that they're well versed and can do this easily. It's not easy for anybody. But we do help the clients get ready for it, so that they look very well polished and able to present themselves. But we don't want to present a fake looking version of our client. And because the judges will see right through it. They are sitting on the bench because they have demonstrated that they know what the law is, and they also have a good acumen for how to read people and how to know if somebody is being forthright and honest, or if somebody is trying to manipulate the court.
So I know from having been a divorce recovery leader for 20 years myself, I know how important it is to walk into that courtroom and appear like a sane human being, just
Yes.
be self-composed, have some self-respect. Don't come in there screaming and yelling and crying and breaking down.
Mm-hmm.
Bring in, if you've got evidence, have the evidence. If you don't have the evidence, be honest about it.
Yes.
So.
Yep.
Okay.
And I mean, I've been on the other side, and I've sat on the stand myself. So, and I always tell my clients that one of the reasons that I can help you through this process is I've been through this process. And thankfully, now 2 decades later, I can say that it was a dark tunnel for a little while, but there is definitely a light at the end of the tunnel, and you will be okay.
I love that message. You will be okay. It is a dark tunnel, but there is light at the end. Now, another thing that a lot of people worry about is that their ex has always lied to them, lies, 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 and they're going to continue lying in court, and they look so believable, they'll be believed. What do you tell them in that case?
A lot of people can come off very well, and there's a lot of people out there that don't know the truth, even when it's truth or lie, even when it's coming out of their own mouths. But a spouse that has been continuously abused by a narcissistic partner or has been the brunt of parental alienation, oftentimes they start believing these things about themselves. So they hear the message that that person is saying much more so than a court or a judge that has no emotional involvement and doesn't have that cognitive bias against one person or another. They're not going to necessarily let in the messages the way a person who's been committed to a relationship will let in the messages.
Mm. So they're just not going to fall for them as easily. They'll maybe ask for evidence or
Yes.
proof of,
Yes.
of their allegation.
Yes.
Total switch of topic here.
Okay.
Because you brought up parental alienation, and it's pretty common in my private Facebook group, the Life Saving Divorce, that we have a lot of people of faith, people of deep religion. And so, and often they're married to someone who also has faith, or at least claims to. And that person tells the children, your mom or your dad is filing for divorce. They are a sinner. Your mom is a sinner. She's the one breaking the marriage. Or your dad is the sinner. He's the one, breaking the marriage. How do you protect yourself from that?
There are resources and tools, and honestly, your book is one that I recommend to a lot of clients, particularly people of faith. But even there's some people who, have come from other faiths that they have benefited from reading that book. There's other great books that are out there, like Boundaries is a fantastic one. There's basically a whole group that's committed to parental alienation and has some great resources and tools online that people can look up. But again, it's a lot of times with the children, you have to take the high road and you have to consider their ages. The advice that I would give to somebody that has a 6-year-old is not the same as somebody that has an 18-year-old. Obviously, you're going to be much more open and honest with an 18-year-old because you're wanting them to understand what a healthy marriage looks like and let them know that that's not what they've witnessed, that healthy parenting is not what they've witnessed. My own mother told me the best thing that you can give your kids is 2 healthy and happy parents. And so sometimes that happens to be a part, and children don't understand that. A 6-year-old will never understand that. In a 6-year-old's mindset, they're supposed to have a mom and a dad, and ideally they would. The next best thing is if we can give them one healthy parent that is functioning very well and taking care of them most of the time, or 2 healthy parents that are able to happily co-parent that child. A commitment to co-parenting is actually one of the things that the courts look on very favorably. And the parent that is not willing to co-parent usually will come off very poorly in court.
Okay, so they'll come across poorly in court. The problem is sometimes you don't want to co-parent with that person because they legitimately are violent, demeaning,
Yes.
hostile to the children. So how do you express that to the court without coming across as being the problem? Because boy, we've got a lot of, I've seen both men and women who say, wait a second, my ex is really abusive. And then they look like the bad guy, right? Yeah. The person who's bringing it up in court looks bad.
No, the person who's reporting abuse does not look bad in courts, particularly if they can demonstrate with the evidence that they have that this behavior is taking place. text messages that are exchanged between the parties, emails between the parties, witnesses that can attest to these bad behaviors. And no judge is going to put a child in harm's way and force parenting with an abusive spouse or ex-spouse or co-parent. The judge wants to make sure, again, that the kids are healthy and happy and safe. And so that's any abuse issues have to be addressed.
Okay, so let's say that your ex leaves you a voice message that says, if you follow through with this divorce, you'll never see your children again. And you're just a blankety, 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 blank. What do you do with that voice message?
Without knowing a bigger context, it's hard to say. I mean, is that a person who should legitimately be calling 911? That may or may not be the case. There may need to be a criminal component if it reaches that. And primarily what I do is on the civil side, it's family law. It's not criminal law. But you need to make sure that you're saving those text messages and that you're letting the right people hear them.
So save the text messages, save those voice messages that are hostile, that involve threats, yes, that involve what other things? Because you just said something that I don't think many people realize. There can be a criminal component to your family law case, and which needs to be turned into law enforcement. Yes. You need to call 911. You've got to, call the police if it becomes criminal. So it may transcend, and I'm not sure I'm using the right words, but it may not just be a family law matter.
Yes. Yeah. If somebody is feeling genuinely threatened, they first need to call 911 because we are not equipped to handle, them being safe and being in a safe environment. That's not what the family law attorneys are there for. That's what law enforcement is there for. And we will work with law enforcement to make sure that any protective orders or anything like that are in place. And we can also help out with protective orders in cases that don't rise to the level of family violence, but are concerning. We can do a civil protective order as well.
I'd love to know more about that because a lot of people say, I called the police, but they didn't think it was a big enough deal. So they didn't even write up a report. What do you tell them?
That's where you may need to get a civil protective order. And one thing that we will ask for in the civil protective order is a recording of that 911 call. We can subpoena the police department records and get the recordings of the 911 call, as well as any documentation that they've made on their end. Including their, did not follow through notes as to, why they didn't address this issue.
So and even if they blow you off, as long as you've got a recording of you calling them,
yes,
your attorney can subpoena their records. Oh, that's good to know. Excellent.
So we can subpoena the police department records, and we may use that as evidence for a civil protective order. And civil protective orders can still help people to have boundaries where a person can approach them, be within 500 yards or whatever the attorney says is right. Where an opposing party won't be allowed to go to a child's school or an individual's workplace.
Oh, wonderful. That's excellent. Another big question that people have, and I know it's different in every state, is once I get that person out of the house, can I change the locks?
So most counties will have what's called a standing order that's attached to the original petition when it's filed. And that's a petition for divorce or a petition in a suit affecting the parent-child relationship or custody modification, as it is, that says, you can't make any major disruptions. You can't unenroll children from school. You can't, if in a divorce case, you can't cancel the homeowner's insurance. You can't cancel the electric bill, electric service to a house. You cannot disrupt those things while a case is pending or until further order of the court. Because then typically what will happen is we'll go and we'll get temporary orders put in place. And that'll be either by agreement or after a hearing, where it will say this person has exclusive right and use possession of the house. Each person has the exclusive right, use, and possession of their vehicles. This is our temporary children's possession schedule. This is the temporary arrangement for how all the bills are going to be handled.
Okay, so if you've got that exclusive use of the home, then that person is not allowed to come in.
Yes.
I assume you call the police if they do, or if they're hanging out or something like that.
If it escalates to that, you can then call law enforcement and show them what your orders say. You would hope it doesn't come to that. You would hope that somebody will take, no, you can't come in for an answer. But yes,
Yeah.
you can call law enforcement once temporary orders are in place that give you the exclusive use of the house. And in some
Okay.
cases, it may take 6 to 8 weeks to get temporary orders in place. In emergency cases where there's some level of demonstrated abuse or harassment, that could be in place in 3 days.
Oh, wow. Okay. And then, so in Texas, you could change the locks or not change the locks?
Unless the court tells you it's okay to change the locks, typically you don't change the locks.
Okay. Okay. Because I know that every state is different and people can really get in trouble changing the locks unless their attorney says it's okay.
Yeah, almost
Okay,
every state, every county has those orders that say you cannot create major disruption, and changing the locks would be a major
that counts as a
disruption.
major disruption. Okay, good to know. Now, another big question people have is the money in my bank account half mine? In our joint bank account, can I just take my half out of the bank account? Because, I'm worried that if I don't, my ex surely will and leave me with nothing. How do you handle that?
There's a small percentage of states that are not community property states in the United States. The majority of the states are community property, which means that the person who's been a stay-at-home mom for 20 years is equally entitled to whatever funds that the couple has acquired throughout their marriage. So, husband or wife's IRA and 401k are considered property of both the husband and the wife, not just one individually. So again, this is for a community property state, and there are some states, and in fact, some very populous states like New York that are not community property states that have a different set of rules. But as far as trying to make sure that you have the funds that you need to survive, again, that's something that you can address in temporary orders. If you have a bank account that has $10,000 in it and you need $5,000 to pay for your attorney, you're okay to pay $5,000 for that attorney.
Even if you've been a stay-at-home mother for 20 years, you've not brought in a dime.
Yeah, attorney fees are considered a reasonable expense in the court. And paying your car payment, paying your car insurance, all of those things, can be taken out of your joint bank account. This is not the time to go and book the $2,700 trip to Cabo. That's not considered a legitimate expense that's necessary during the pendency of a case. Mm-hmm. Even though you might very badly need a vacation, you should not be using your community property funds to take that much needed vacation.
Okay, but any legitimate,
yes.
Legitimate reason you can use yes. the family funds.
Your child happens to have a $1,500 soccer club fee that's due. You pay for the kids' fees.
Okay, that's good to know. Kind of understanding just generally where the guidelines are, and when in doubt, for one's own particular case in one's own particular state, call your attorney.
Yes. Right. One other thing that I didn't mention earlier that's also very helpful, like our office primarily communicates with our clients by phone or by email, and it's often advised that you create a brand new email address that will be specifically for your case-related communications. so that you
Okay.
don't miss something from your attorney. And also you're reducing the risk of your ex, getting into your email and finding out what's been going on because you've had a shared computer and you've accessed that email on it previously and you've saved your password.
Yes, right. Good. Do you have other, I mean, the whole password and email thing, would you remind people about the legality of hacking into someone else's email?
Yeah, don't do it. Um, you cannot, even if it's the spouse that you've had for 30 years, you cannot be hacking into their phone. You cannot be putting software on their phone so that you can record all of their conversations or track their location. Um, you cannot be hacking into their emails. However, here's the disclaimer on that. When we get into the discovery process, we can request all of their emails. We can request all of their usernames and passwords. We can request that they download all of their social media accounts and Tinder, Bumble, those type of accounts.
Wow. So
So
the online dating things.
yeah, no information is really considered off limits. You just can't go get it yourself without having discovery and process.
That's super good to know. So, do you typically recommend that people get off all social media when they're going through a divorce, or do you want them to kind of present sort of a wholesome, family-oriented look on social media?
They can be themselves on social media. One of the worst things they can do is scrub their social media. There's a woman shares her, picture 4 or 5 months ago. She's out at a happy hour with her girlfriends and they're toasting somebody's celebration. And she's looking very happy. She has a great group around her. She looks beautiful and she is consuming alcohol. Everybody's like, I should take that down because it doesn't paint the picture that I'm miserable, that he's made me miserable, and that I drink.
Right.
Um, it's going to come up. And if you try to scrub your social media, it will only make you look worse. Just be who you
Mm,
are. Obviously, we don't want you, once your case is filed, putting things out there, inappropriate selfies. You don't want to be Facebook messaging somebody that you met online who seems to get you.
like a possible romantic connection.
Yes,
Okay.
yes. And once you put out there that you are in the process of a divorce, somehow this high school friend from 30 years ago will show up and be like, hey, how are you doing? And you think you might just be having this friendly conversation with them, but it can be misconstrued. So just be mindful of what
Yeah.
you're putting out there.
Okay, so be really cautious if some potential new romantic interest shows up all of a sudden. Just watch what you say
Yes.
because it can all be subpoenaed. Now,
Yes.
okay, so let's talk about being in a group like mine. I've got a private Facebook group. Can that be what they post in my group be subpoenaed? And what do you recommend that they do?
Unfortunately, yes, it can be. You would hope that somebody can find a safe environment where they can say what they need to say, especially if they're in an abusive relationship. But if it does get subpoenaed, if it does come out, the best thing you can just do is own it. Say, yes, I was complaining about my narcissistic ex. And if you
Okay.
had to deal with this stuff, you would too.
Okay, so you're basically saying, yeah, I complained about them. Yes, maybe I disparaged them, but my life is a nightmare because of what this person is doing. And yeah, I told 2,000 people in my private Facebook group about this.
Yes.
Okay, okay. Does it ever help to prove that you've been talking about what's been going on for a long time, or is it kind of neutral?
It really depends on the environment that you're talking about it and what you've said. So
Okay.
if if it's just a venting session, it's probably not helpful. But if it's, if somebody is actually making an outcry, if this might be the first time that they've ever actually voiced that they have in fact been abused, that might be something that's good to have.
Okay, let's say that this happens from time to time in my group. Here's the picture of the bruise on my kid's arm. They just came back from being with dad, and look at the size of this bruise.
Yep.
That might be a good thing
Yes.
or a helpful thing to put on your private Facebook group
Yes.
page. Okay, because it's a form of evidence, and it date stamps it or
Yep.
time stamps it. Yeah, of when it happened. Okay. All right. So, how do you, let's say that you've got a really tech savvy ex, maybe they've been in military intelligence, for example. I mean, they know all the ins and outs. Is there a way of sweeping your phone and sweeping your computer and even sweeping your car to make sure there aren't any GPS devices? And after you answer that, what about if they put like a nanny cam in your house and you're still sharing your home together? And so they're listening. There might be one, near the phone. What do you do about that?
Laws vary by state. In California, I know, for example, you have to have two-party consent for any recording. In Texas, you only require one-party consent to recording. So if I am on the phone and I want to record a conversation with my ex-husband, I'm in my right to do so. My ex-husband is in New York. I don't believe that he is in his right to do so. I believe that's also a two-party consent state.
Like California is, yeah.
Yeah. So that's just something to be mindful of. And yes, we have available to us computer forensic specialists that can analyze your phone and determine if there has been spyware put on your phone, and can access what exactly they've collected from your phone. We have investigators that can sweep your car or your phone, your car for locators and also recording devices.
Wow.
So if that's something that you're concerned about, make sure that you bring it up to your attorney, because we'll happily point you to 2 or 3 different places that we can address the issue.
I mean, that really puts in the spotlight the importance of hiring someone who really specializes in family law. Because I would imagine, your average business attorney wouldn't have those kind of contacts.
No, and having an attorney that doesn't specialize in that area, not only will you be at a disadvantage because of the contacts, but if they don't know what they're doing, it's going to be harder for you to get a successful outcome, for one. Or if they're really committed to trying to do it right, they're going to have to put a lot of time and effort into it, which is just going to make it more expensive for you.
Okay. Yeah. Why waste $1,000 on someone who's having to learn how to do family law when
Exactly.
You can spend it with someone who lives and breathes it every single day? Yep. Okay. So here's another really hot question. I'm throwing all the hard balls at you.
That's okay.
A lot of Christians say, I don't want to be the one who filed for divorce. And yet my legal friends say you probably should be. If you know you're going to divorce, you ought to be the first one to file. Tell them, give me the pros and cons of that kind of thinking.
In most cases, there's not a disadvantage or an advantage to being the one who files first. It just is what it is. I see a lot of people who try to avoid process service because they think they won't have to get divorced then. There's other tools in place. If somebody is very committed to leaving, avoiding process service is not the way to stop a divorce. I think people have to find, if they're really feeling ambivalent about it, they need to make sure that they're connecting with the right person that shares their faith, that can help them through a lot of the emotional and mental pressures that they're feeling, in addition to the relationship pressures that they're feeling.
Yeah. Yeah. Does it make you look like you're a victim? I mean, does it give you credibility as an abuse victim to be the one who files? Like, I can't take it anymore. I've got to file now. I got to get out.
It can be. It
Okay.
can. It again, it all depends on the bigger context of things. If it's a case of severe abuse and you have let it go on for years and you haven't done anything about it, and then the other person files and then you try to claim that you've been a victim of abuse, that can come back to hurt you.
Hmm.
um, or
Because it looks
especially
like
if
you
you
just
find
made it up.
someone, yeah, especially if you find someone that's been abusive toward the children, because then it not only looks like you're either not being honest, but it can also look like you have allowed the children to be put into a bad situation and you didn't stop it.
Okay, so that brings up the big question. We just had it on the Life Saving Divorce private group several weeks ago. You know, should I call the police every single time he hurts the kids? And what would you say?
If it's a bruise because the child fell off of their bike, no. If it's a questionable bruise or a pattern of questionable bruises, I would definitely call law enforcement and get them involved.
Okay. And even if they don't take you seriously, you've already told us that as long as you're recording it on your end and you know the time and date that you called, your attorney can subpoena that.
Yes.
Okay. That's good. That is so good to know. Do you ever have problems with guardians ad litem who don't believe the abused spouse?
I think it happens occasionally, but most of the time that we have to deal with either amicus attorneys or guardians ad litem, um, most of the ones that we encounter are committed to finding the true and the just outcome. They're ethically bound attorneys just like anybody else, and they really do want what's best for the children. And it's important that parents take an active role in communicating and allowing time for the guardian ad litem to do their job. A lot of parents do want to shut that third person down, and they're just trying to protect a child, but at the same time, they don't realize that that child does need to be heard and represented too.
Okay. So that parent becomes too emotional?
If they're not participating in the process, it's not showing a commitment to trying to find what the best outcome is for the child. You have
Okay.
to make
So
sure that
you've got
you
to
are
look like
participating. Yeah, you want to make sure that you're participating in the process.
right, right.
And that's what I find that people tend to not do most of all.
Yeah.
They don't want to have to deal with this other person. They they're annoyed that this other person is coming over to their home and talking with their child and maybe even opening the refrigerator or going to one of the child's athletic or school events. It feels intrusive. It really does. Everybody would probably feel really self-conscious being under that kind of microscope. But the more that you participate in the process and cooperate with the amicus or guardian ad litem, the better off everything is going to be.
That is a very good piece of advice. Be cooperative, accept the fact that they need to see you at the soccer game, see you and your child interacting. Really important. Let me ask you about forensic evaluations or forensic psychological evaluations. When might you, well, is this something that the attorney asks for, that the judge asks for, or that your client asks for?
It's typically something that's requested by the attorney. I have seen cases where a judge has ordered it, even though it wasn't initially requested because concerns came up during a temporary orders hearing. But typically it is requested by by one attorney to the opposing party. And yes, you do have to make sure that you are trying to stay in compliance with everything if you're the one who's being requested to be evaluated. And, you know, if you're the one who's requesting an evaluation, you want to make sure that you are finding the best forensic evaluator that's available to you in your area.
So I went through one at the request of my ex-husband, who was wanted to convince the court that he should have custody. And so he paid. He selected a forensic evaluator off the court's list. It was a pre-approved list that the court had. He chose the person. I don't think I had any say about it. He paid for the person. And we went through about, between us and the kids, probably 18 hours of being face to face with this evaluator. So of course it's very, very expensive. And then the evaluator, who is a PhD level psychologist, called, I think, probably every single counselor we ever saw, any other, like a pastoral counselor, even interviewed family members, which shocked me. I did not know that they would do this. And got back a very extensive report that, of course, we were told we couldn't have a copy of it, nor could we show our children, because they didn't want us, influencing the kids. But it was I was terrified, to be honest with you. I was just scared because, none of us is perfect, right? And so it was really, I was very grateful to have gone through that, because in this case, even though my ex-husband had paid for it, the evaluator found that I should continue to have sole custody, and my ex-husband should continue to have monitored visitation. And so I was very grateful. And the judge used that to say, stop coming back trying to get joint custody, buddy. Lay off of this for a couple of years. You come back in 2 or 3 years, but lay off for the next year or two, okay? And I was grateful for that too, because I had been dragged through court, every year for many, many, many years. So, people are worried that these evaluations will turn up something horrible about you, but only they can weigh, the pros and cons of going through one.
Yeah, it's a fantastic tool to have. A lot of times, if we're trying to flip custody from one parent to another, it's crucial to have something like that, so that we can demonstrate to the court, why this needs to happen. Because typically in Texas cases, a trial will be 1 day in court. So you're looking at 6 hours for the judge to try to get as much information as they can possibly get to make a decision, versus, like you said, 18 hours of really in-depth interaction that's been boiled down to 5 pages that a judge can read in 5 minutes. So that is it's a fantastic tool. It is expensive.
It was expensive. I went through it, I don't know, 15 years ago, and it was expensive. I can't imagine now. But one of the comments that comes up in the private Facebook group is, can my ex game it? Can they game these big psychological tests? And it turns out, now I don't know what tests are used in any particular state, but the one I had 15 years ago in my state, my ex-husband did try to game it. He tried to answer the questions as if he was a normal human being, and they caught him. They nailed him. They have these tests are so good that they can. I'm sorry, I don't know the proper terminology, but they know whether you're trying to weasel through this test and appear to have no psychological problems.
Yeah, the baseline tests that we have seen on those, in the very beginning will actually weigh someone's commitment to being a truth teller versus somebody who is putting out a show or putting on a face. And through their series of questions, they can actually boil that down right from the beginning. But like you experienced, the evaluation went much farther beyond that, because it did include not just the psychological testing, but it did include the in-person interviews, the witnessing the interaction between the people, the accessory interviews that take place too.
Yeah,
And
it was
most
amazing.
evaluators will also review all of the legal documents in the matter as well, and all of the discovery that.
Oh, wow.
Um,
That's amazing. I didn't know that.
yes.
So you've actually seen cases where you can flip the custody with a forensic evaluation.
Yes.
Wow. Wow. Well, that's what my ex-husband tried to do to me. He found a counselor who didn't know him, and he snowed the counselor, and that was enough to have his attorney recommend the forensic evaluation. So anyway, in my case, it worked.
It ended up coming back
out
in your
well.
favor.
I was very, very grateful. What other questions? I mean, I feel like I've lobbed at you like the worst questions, but they're questions we all want to know, and they're all questions we ask each other. What other questions? What haven't I asked?
I think we have covered an awful lot. Again, I think you just have to, the best way to handle it is to always be completely honest, always be completely yourself, always find counsel that you can be completely yourself with, be it legal counsel or therapeutically, so that you can address what's going on and not get taken by surprise when you do end up in the legal system.
Let me ask you this. A lot of people hope, especially Christians, a lot of Christians hope they will get moral vindication in court. They will finally have that judge say, what was done to you was really, really wrong. This dude or this woman, in the case of women who are abusive, is a horrible human being, and I can hardly wait to grant you this divorce because that person's so awful. That's what they want the judge to say, but of course, that's not the judge's job. What do you say to people who want that?
Some judges will put in their 2 cents about the moral circumstances of a case. The court's job is to make sure that somebody is made as financially whole as can be done, and to make sure that the children are being brought up in the best environment they can be brought up in. I've often told people, they're like, well, I want this much more money because so-and-so committed adultery. And unfortunately, the laws are made by politicians. And as long as politicians are writing the laws, there's not going to be major penalties for adultery.
When your adulterous politicians stop committing adultery, maybe we'll see more.
They're not going to legislate themselves into a corner. So people have to be mindful of that and just take that for what it is. The courts are trying very hard to do the right thing, but you're not going to get the moral and emotional support that you need from the court system. If you want the moral and emotional support, you need to find your faith group. You need to get into something like divorce care or other organizations like that are there for the purpose of supporting you through this process and afterwards. And you need to make sure that you're being plugged in socially with groups like your Facebook group, where people can try to work through the emotions of it that the court just doesn't have time for.
That is a great advice. People really need support and encouragement, someone to listen to them. They don't want to burden their single friends because their single friends don't understand. They don't want to lay it all on their married friends because they really don't want to impose. And so there's no place to go for support and encouragement. And so faith groups like Life Saving Divorce on Facebook. There's a lot of good Christian groups on Facebook that support, especially abuse victims or infidelity victims. Finding your voice, on those kinds of groups, and finding just one friend who's walked the path before you makes a huge difference. So
Yep.
anyway, thank you so much for your time. I really appreciate it, Laura. And wow, this has been really great. Thank you.
Well, you're very welcome. I don't mind doing this at all. I mean, it's not just my job. It is, coming from somebody who has been through the divorce process. And I tell my clients that I raised 4 kids. My oldest turned around and had 4 kids herself. So I must not have screwed her up too badly.
There you go. Let me ask you on a personal level. So far, you've been just helping me as a professional, as a paralegal. What helped you make it through the process? All the fears about going to court, all that. What helped you get through it?
I think faith had something to do with it, but a lot of it was just knowing that enough was enough, and that I was modeling behavior for my children that I didn't want them to model. I didn't want that marriage for them. And, my oldest, the one that I mentioned, has 4 kids. She's had her ups and downs in her marriage, but she met her now husband when she was 17. And they have been together for 14 years now, 15 years, and
Good
have
for
4
them.
children. And she's seen a better way. They've had their little scuffles, and they had the tools, the communication skills to work through those things, the perseverance to work through those things, and to want to do it. My second daughter got married just a couple of years ago, and my youngest, my only boy, is now engaged to an absolutely fantastic girl that I couldn't have picked out better for him if I wanted to. And that was really what got me through, because my son was 4 when I went through it.
Mm-hmm.
And now he's 26, and he knows what healthy relationships look like. He also knows what strong women look like. And he admires that. And my soon-to-be daughter-in-law is a very strong woman and very capable, and they are going to have a fantastic marriage, I'm sure. That was the big thing for me. But I will tell you, one of the best days of my life, right up there with the births of my children, was that day that happened about 4 months after I was divorced. And I sat down with my checkbook, because we didn't pay things online back then. I sat down with my checkbook and I paid all my bills. And there was a little bit of money left over. And I think at that point, I finally let out my breath. And I sighed. And I was like, it's going to be okay. We're going to be okay. And that's what I tell my clients.
Pay one bill at a time. Eventually, it's all going to be okay. That's such a great message, because it feels you've got all these fears in your mind. What's going to happen to us? Will I be able to keep a roof over the head? Groceries on the table?
1.5 years holding your breath.
Yeah.
And then you exhale.
Exactly. My father told me, he said, don't, pay one bill at a time. Mm-hmm. Don't project all the fears and all the mishaps and everything that can go wrong in the future. Just bring each day's needs to the Lord, pray about them, and trust the Lord. And I honestly don't know how we made it through that first year. And then, but we did. We made it through. We paid every single bill. And it took me a while to get on my feet financially. I think it took me about 5 years to pay back my parents for all the money they lended me through the divorce. And it took me another couple of years to start being able to start putting money in retirement. But wow, what a great feeling to feel like I did it. I did it myself.
Yep. I'll give you one little trick on that sort of thing, by the way. Instead of having your parents loan you money to pay your bills while you're going through this process, have your parents open a secure credit card for you. If you haven't established credit in the past, load that $5,000, $10,000 onto the secure credit card and use that to pay your bills. And you're now establishing your own individual credit identity during this process.
Oh, that's awesome. That's really great. So you're building your own credit, especially for the stay-at-home moms who've not got much or any credit in their own name. That's a great idea. Any other quick tips?
I think that's about it for today.
All right. Well, thank you so much for your time.
Thank you.
I truly appreciate it. And congratulations on your children turning out so well. And what people don't realize is that most children of divorced parents go on to have successful marriages themselves. So, all right. Thank you so much.
Thank you.
Bye-bye.